scheduled. That is case number 111444, State of Kansas v. Darren Ingham.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing this morning on behalf of Darren Ingham. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Your Honor, this is a criminal case out of Reno County. The underlying facts are largely undisputed, that my client was taking some rocks, apparently he got from Colorado, and taking some gunpowder and putting it in a Coors Light can, and putting these things all into a cement mixer and blowing them up, ostensibly to try to get gold out of those rocks, I guess. And for this, Mr. Ingham was charged and convicted by a jury of criminal use of explosives, a severity level 6 person felony. And this is his direct appeal.
It had to be a commercial explosive or not under the statute?
Under the statute, it has to be commercial
explosive. Okay, that's what I thought.
Sort of the title,
was.
the name of it
Yeah.
is criminal use of it. And in fact,
it matters for the one instruction issue.
That's
That's
right.
why I wanted to clarify.
And in fact, Your Honor, my intent today to argue is primarily to highlight a couple of things about issue 2 and 3, although I increasingly understand that I'm bad at predicting what the court wants to talk about. But issue 2 in this case has to do with the testimony of Officer Lutz in this case. Because again, the underlying facts sort of really aren't in dispute here. My client admitted that he did these things. The question at the jury trial then is, was it illegal? Was he guilty? And so this question...
Your issue 2, we can just talk about that briefly. It was the question put to the officer was on redirect examination, as I recall, and it was after cross-examination of, isn't it legal to own a can? Isn't it legal to own this? And isn't it legal to own these three components that made up the device? And then the follow-up was, well, is it legal to combine these things to make an explosive device? And he basically said, no, it's not legal. I understand your argument if that was just a conclusion that was based on a direct examination, but in the context here, it was in response to the direct examination. Is there any, what's your thought about that?
Sure.
Can't the state respond in that manner? Collectively, these things as they were used was illegal.
I don't think it's appropriate for the state to elicit testimony regarding what the jury is going to be deciding in this case, whether or not the use of those things in this case was legal or not. And so, was it in response? I think so. I mean,
yeah, it was.
I mean, that's
right.
that's the record, but the questions, and I don't know whether maybe the questions from defense counsel weren't proper. I haven't really thought about that. I think they probably were, but in any case, the point of the issue is taking those things and putting them together. Is that legal? And so the question is that proper? And we didn't really dispute it. We said we didn't know if it's expert testimony. I kind of assumed it's expert testimony. But is it proper expert testimony to say, expert, if these things are true, has a law been violated? Really? I mean, that's what he says. And we would and do argue that does cross the line. That I understand that under 6456, this court has said it may be that experts touch on ultimate issues of fact. And for example, what might be proper testimony in this case for an expert would be, so this was something called Pyrodex powder, I guess. I had no idea what Pyrodex powder was before this. And so maybe an expert would testify, Pyrodex powder is gunpowder. And that's related to the ultimate issue in here, with what kind of substances are you using. So maybe that's proper.
If the question had been, is it possible to make a commercial explosive using legal items, You wouldn't object to that.
I would object to that because I still
would?
think that's too. I mean, the element of the offense in this case is using a commercial explosive. If the officer had testified, is Pyrodex a chemical compound that forms an explosive? That's where I think it's a little bit harder for me to make that argument. And even though I understand that touches on an element of an essential element.
This is a fine distinction, but let me just make sure I understood your answer to my colleague's question. If the question was, is it possible to construct a commercial explosive using items that it is legal to possess, that would be too far? Not focusing on the items here, but just because defense counsel, the point of defense counsel's questions, of course, was these are all legal items, weren't they? I mean, it was just legal to possess all these items. It's the putting them together that causes potentially your client a problem.
And the specific question that you posited, Your Honor, is
Is
would it be possible for
is
that
it
to be a
possible?
commercial explosive?
No.
It's a different question
Is it
than what was
possi-
asked in this case.
Okay, and so the line that was crossed was focusing on these items, uniting these items in this way is a commercial explosive.
Is it illegal?
Ultimate fact of the issue.
And draws that there's a line that
Not to mention, this wasn't a lawyer or a judge testifying, right? And if to the extent it was legal opinion, then they were out of their area of expertise.
I mean, this court has drawn that line before, of saying these might be factors that show, or.
Can I ask a question about
yes.
issue 3? Unless you have some more on that. Anybody else? No? Okay. I think I've got them numbered the same way as you. Issue 3 has to do with the jury instruction that said something about an improvised explosive device, comma, commercial explosive. If that instruction had said instead, commercial explosive, comma, to wit, improvised explosive device, you would have a harder row to hoe, right? Because we've got language in other opinions that says you can give the item at issue in the case as an example of something that might fit the definition. The problem here is that the judge's instruction may have defined the item as a commercial explosive, which
I would have a harder road to hoe if that was the case, because I've lost that case here before.
okay.
And
forgot
so I
it
know
was
that,
you,
but
I
yeah,
knew that someone
and I think that's one of the distinctions you would have. Judge Levin cited those cases or those
Right.
kinds of cases,
Right.
but this is a different construction, and I would separately
In
object.
essence, this directs a verdict on an element. That's your problem with it, right?
It allows the jury, because even in the cases that I've lost, the ones that you're citing to, it's still that thing that to wit a knife or to wit baggies, whatever it is that might be used as an example of the thing that is illegal. The jury instruction you've held says it still makes it clear they have to find the element, drug
Right.
paraphernalia, whatever.
Right.
Here, the construction of this instruction says you can do this by finding that it's an improvised explosive device, a thing that's not even
Does it make a
defined in
difference
law.
here, though, that in those other cases, there wasn't a definition offered? Here, there was a definition specifically describing what a commercial device is. Does that make a difference? Doesn't that allow the jury then to say, here's the definition, yes, this fits?
So
So isn't that different than the other cases where it just implies that you're directing a verdict? Here, there is a definition of what the jury is defined, is to find.
So no, for two reasons, Your Honor.
Why? Yeah.
One is because the fact that the definition is there, again, we have to think about a jury reading this instruction. Instruction 10 says, what do we have to do to convict this person? Well, we have to see that he possessed an improvised explosive device, comma, and a commercial explosive. A jury, I think, could very reasonably look at that and stop. Is this an improvised explosive device? Yes. Why do I care about the definition of a commercial explosive any longer? The second reason I don't think it's right, and again, I understand the court has to take into consideration the entire instruction, but I mean, the next part of this instruction, and this is quoted in the Court of Appeals opinion, is it is not a defense to this crime that Darren Ingham did not know an improvised explosive device was a commercial explosive. So even other parts of that instruction connect those things directly. And so we think that this is distinguished from the previous cases where this court has said, even where there's an example of the sort of a limiting example, that that's not this case.
So the second sentence suggests again that that element, there's a directed verdict.
If I was a juror and I read, if there's not a defense of this crime, did not know an improvised explosive device was a commercial explosive. If I'm a juror, I think I would read that and say, it seems to me like the judge is saying that an improvised explosive device is a commercial explosive. And that's Bryce. And I don't think Bryce, you haven't overruled Bryce. And that's exactly what it is.
So your problem is with the way a commercial explosive was characterized in this trial, not with the underlying statute that defines commercial explosives.
We did not raise any issues about the underlying statute, no.
Okay.
Your issue is you can have an IED, which is not a commercial explosive.
Yes. Your Honor, that's all I had planned to highlight.
Can you address harmlessness on both issues really, but in particular on that first issue? Why is that question and answer to the officer changing the verdict here?
So, I mean, and that's an interesting part, I think, of the Court of Appeals analysis in this case. Is they sort of say, who cares? Because it clearly, in their mind is this thing, a commercial explosive device. But the jury has to make that decision, and really anything that sort of impedes that decision in this case is certainly error, and we're in, I think, that constitutional harmless error world where you have to be able to say, beyond a reasonable doubt, it couldn't have affected sort of the outcome.
On the question and answer, you think is constitutional on what basis?
If it invades the province of the jury.
Jury, is that's
it's
the tie that you would make?
Yeah. And so, I guess obviously I have a different view of the strength of the evidence in this case. It's not that obviously there's a dispute about what happened, but the dispute of what the effect of that is. And whether or not doing something like this, could a jury view this thing and say, okay, so he was doing this, but does it sort of fit what we think is meant to be prohibited under this statute?
Well, and along those lines, I mean, that goes to my earlier question. You started out by saying these things happened. We're not contesting the facts, and we're not contesting the underlying statute. And the underlying statute is incredibly broad. You're just saying give the jury a chance to ignore the statute is what it sounds to me like you're saying.
No, I'm saying that in a jury trial, regardless of the strength of the state's case, it's still critical that the jury make the decision that my client's guilty beyond a reasonable doubt of all the elements of the crime. And just because there's a broad statute doesn't mean that a jury has to adopt that statute, the application of that statute, in a particular case in particular circumstances. That's the real problem. I understand Judge Lieben thinks that this is criminal use of an explosive, but my client's entitled to have a jury decide that this was criminal use of an explosive.
But
and the
when
instructions...
No, I understand the point. However, the difficulty comes when we conduct our harmlessness analysis. We do ask the question, but for this error, do we think that the jury would have done anything differently?
Yeah.
And so why should we think the jury would have done anything differently?
Particularly when you look at all the circumstances of this case. I was talking about this with my colleagues before for argument, describing what happened here. And one of my colleagues said, where I come from, that's just a first date. It's really not that bad. And I mean, can you say beyond a reasonable doubt that a jury might not have looked at this and even said, and I'm not really talking about these things from a nullification standpoint, but just saying, look, we think that this statute and the idea of commercial explosive, we can apply our common sense also to that idea.
To disregard the language of the statute. And again, I just come back to for example, a commercial explosive includes an incendiary material, liquid or solid. I mean, is a matchstick a commercial explosive?
It's very broad. I had some thoughts about that, but the fact that it could be, we're not arguing sufficiency of evidence in this case.
You're really arguing, should we consider the possibility of jury nullification in our harmlessness inquiry? That's what I'm asking.
I want to make sure I got all of your question, Your Honor.
can we or must we consider the possibility of what is effectively jury nullification when we conduct our harmlessness inquiry?
The answer must be yes, because to the extent that you're going to adopt and have adopted sort of this outcome-based harmless error test, then that's a possible outcome and a valid outcome.
Why else would we reverse on the through and through gunshot wound? Because it's hard to imagine that doesn't fit great bodily harm in our minds. And so we've already said that, you know, the jury, right to jury is so important that even what is pretty obviously a egregious wound has to be found by the jury.
It just seems like you're arguing structural error as opposed to clear error.
I understand every case is individual, and I'm asking this court to view the entire circumstances of this case to find that is there a reasonable possibility a juror or jurors would have come back differently had some of these errors not occurred, and I think the answer is yes.
I need to follow up on what Justice Rosen just asked. On the first issue, you told my colleague, Justice Lukert, that the constitutional harmlessness test should apply. On the issue we were discussing, on the jury instruction, there were clear error.
No, we objected to that.
You did object.
And we
Okay.
think it's
I
constitutional
misspoke.
error.
Okay, so that's the directed verdict kind of due process thing. Okay, great, thanks. I thought that's what I had in my head originally, but then I doubted myself.
Thank you, Your Honor. I don't have anything else.
Any more questions? Thank you, counsel.
May it please the court, Andrew Davidson, Assistant Reno County District Attorney for the state of Kansas. In issue 2, the questioning of Captain Lutz at the time of this case hit on, from the defense point of view, the legality of the possession of all of those items. And he asked the detective if it was legal to possess those things. And when I asked the question, if you combine all those together, does that make it illegal? The goal was to help his testimony clarify those issues for the jury.
You actually said, did he commit a crime by doing what he acknowledged he did? I believe I wrote that down as a quote, and maybe that's not correct, but that's a little different, because you're saying he acknowledged he did this. Now, is that a crime?
I think I said, in your opinion, is it legal to fill a Coors Light can with Pyrodex powder, affix a fuse to that device? I drew an objection, take it and light the fuse, and the defendant made his objection. This invades the province of the juror, and he said, objection overruled, you may answer. And he said, in my opinion, is that these legally obtained items were combined to make an illegal improvised explosive device.
What you left out in your recitation, counsel, is that you were Mr. Davidson, correct?
Yes, Your Honor.
Quote, well, he was asked about his legal opinion on all these other legal devices, unquote, which would suggest that's what you're trying to get him to give you in response to your questions, right?
Yes.
Well, is he an expert about what's legal and illegal?
He's been to numerous schools.
No, I mean, he might be an expert about what an explosive device might be, but is he an expert about what is legal and
He's
illegal?
not an attorney.
What, he's not? No, is he an expert about that? Isn't that for the court to decide what is legal
I believe,
and illegal, and isn't it for the jury also to make that determination?
Yes, and I believe that the judge allowed that testimony in as an expert from his point of view, as to what what his interpretation of the evidence was.
As an explosives expert.
Yes,
Yeah.
but In issue number 3, the instruction issue, I believe the Court of Appeals was correct on that issue, that really using the improvised explosive device designator prior to the commercial explosive was a descriptor of what we were alleging he was possessing. We were alleging he was possessing a commercial explosive device, and the description of that explosive device was the improvised explosive device, as testified to by Captain Lutz, where he poured all those items together into one little container, screwed the lid on, stuck a fuse in, and blew it up.
And I understand that that's how PIC kind of sets it up. You describe what it is, and it says then a commercial device. But there really is nothing separating the two. It's how do you get around that it does appear to equate the two? If you just reading it.
It gives there's a definition down below that allows the jury to interpret all of
And I ask
those
counsel,
things.
how does the definition cure that?
It cures it by giving the jury a chance to understand what items can make an improvised explosive device, and then they decide whether or not it is an improvised explosive device and whether that is a commercial explosive device. I think that the statute at the time needs that description of what he possessed, because it wasn't anything. It wasn't like a blasting cap that you can go purchase commercially from a vendor if you have a license and stuff. This was something that he made himself, and it fits under this broad category of a commercial device, and you have to have the jury understand what those items are, how it combines, and I think that it's just a descriptor of what a commercial device is, in my opinion. And really, what Mr. Ingham was doing that day wasn't just simply trying to blow up rocks in his yard. There was evidence that he had gone around to a person at a Shell Oil drilling rig and handed somebody a device and told him to go have fun. So these things, he described it as this was a first, this is no big deal, but he was out handing these around. He was trying to blow something up around by the river. The jury heard all of this evidence, and we think that the evidence was overwhelming, that that's what he was doing. That really, if it was error, and I don't think it was, it's harmless, because the evidence in this case included a full confession as to what he was doing, where he was doing it at, and why he was doing it, to go have fun. And these things are illegal because they're dangerous. He could have blown his fingers off. He could have hurt somebody else with some shrapnel, etc. And so that's,
Counselor,
yes.
are all IEDs commercial explosives?
Well, I think they fit under that definition. Obviously, anytime you make something,
So when the instruction tends to equate them, you're saying that doesn't really matter because all IEDs are commercial explosives.
yes, a chemical compound, a pyrodex loading powder.
I mean, not in this case.
Yeah.
Can you make an IED that doesn't fit the definition of commercial explosive?
Well, this definition even includes putting dry ice in a bottle and to blow up the bottle. That would be a commercial explosive device according to this statute, and that's improvised. You're taking two items.
Well, my question is it possible to make an IED that does not fit the definition of commercial explosive?
I don't think so. I think anytime you make something that's going to explode another item, it fits under the definition of commercial explosive.
Since we're on this statute, the definition of a commercial explosive, do you think that the state is within its constitutional police power to make it a crime to possess incendiary material?
No,
Well, that's what the statute says.
depending on how it's used.
Okay, so there's some measure of discretion that has to be layered over top of the plain language of the statute. That
Well,
sounds like what you
If
just
you're
said.
using the Pyrodex loading powder as its intended use to load,
Does the statute have any description of intent, or is it just pure possession?
I think it's the statute for,
I mean, the statute even says you don't even have to know that it's a commercial explosive. It
but
just
I
says
think
possessing.
yeah, it says possessing it in a manner to create the rupture, bursting of the container, incendiary or explosive material, liquid or solid, detonator, blasting cap, military explosive fuse.
You're reading from the definition of
Yes.
commercial explosive.
And so those items, if you're using it to explode the container, you're creating a commercial explosive. But if you're using it to make a
So you're reading-
round fly out of a bullet, you're using it out as it's not blowing anything up at that point. It's just shooting the
Well, there
projectile
are
down.
exceptions for ammunition,
Yeah,
correct?
and that, yeah. So
So again, I'm just to clarify, your reading of the definitional section would have required that the language placed in a container for the purpose of generating a gas to cause mechanical failure, rupture, or bursting.
that's what makes it an explosive device.
And so the fact that the sentence is separated by a bunch of semicolons that seem to have nothing to do with bursting a container.
I think.
Am
that
I just reading that wrong from your view, in your view?
Yeah, well, I think that once you do something in order to create this reaction, to blow up the container or detonate those explosive materials, then it goes in and it separates out blasting caps, military explosive fuses, symbols, squibs. Those are separate. But when you take generic materials off the street, like peroxide, and you mix it with some other chemical and it creates a compound that can explode, you've then committed the first part of this commercial explosive device using chemical compounds to form an explosive. Those other items are separated out and distinct, but I think that it contains some manner of how you use those items in the statute.
Your choice to characterize this as an IED, which connotates, at least when I first read this, I'm thinking of an IED, which is its intended use is usually a military or radical kind of used by terrorists, radicals, in order to maim, hurt, or kill people. That was never his intended use. What was the purpose of characterizing it, this particular commercial device, as an IED? I mean, would you, if a kid blows up a bottle by using peroxide, would you call that an IED?
Yes, that's how
Just because
the
it's improvised?
officer would have testified. When I asked him prior to court, when you've gone to your training about these items, what would you define this? And he said, well, an improvised explosive device, and any time you take items and mix them together to make something like this, you're improvising something to make an
I
explosion.
understand.
And that's just the definition. I mean,
I understand the literal definition of each term makes this an improvised explosive device, but the characterization is I've just never heard. I'm just saying from my perspective, I would think a juror would have never heard of this characterization used in this means or in other types of contexts. In fact, you look at the definition of this from other sources, all of them relate to a military type of weapon.
but it also relates to the type of type of material that the detective. That's how he would have defined it. I mean, other officers there called it a bomb. The defendant tried to characterize it as a firecracker, but its definition, according to Captain Lutz, was an improvised explosive device, and that's just what it is. It may be sound bad, but that's how he defined it based on his training.
Is there a statute that defines improvised explosive device and goes on to say that that is a crime?
I don't believe so. I think that the criminal use of explosive statute is what covers that type of thing, and then you have to kind of build that evidence for the jury to decide. And I believe that the jury had an opportunity to review the facts, the evidence, and decide that was a criminal use of explosives.
So when the officer testified in response to your question that these were combined to make an illegal improvised explosive device, it is not illegal to have an improvised explosive device in Kansas. Commercial explosive, yes, but an IED, no. Is that
Well,
right?
I think what he was meaning was,
Well, I thought I asked you earlier, is making an IED a crime in Kansas?
I think it is. I think it fits under the criminal use of explosives statute.
Oh, and would you speak to the harmlessness that we spoke to Mr. Hodgkinson about?
Well, like I said, I think that that's how this court has to view it. The facts of this case were strong in favor of the state. The defendant told the officers exactly what he was doing, why he was doing it. He even muttered during one of his statements to the officers, he knew what he was doing was illegal. So I think that the evidence is overwhelming, and that this would have, if it was error, this would have been harmless error. Are there any other questions?
Or questions? Thank you, counsel.
Your Honor, I wanted to make just one point, and it's sort of, it's related to a question Justice Johnson asked my colleague, and it's what's related to some other comments that, sort of this question of, is it, are all, even assuming the sort of broad idea that the officer here testified about what an improvised explosive device is, are they all commercial explosives, is related to issue 4, which I didn't talk about, but the answer is no, because we know that not every explosive device is a commercial explosive, even as defined by the statute, because the statute excludes expressly fireworks, some fireworks at least. And that was part of our 4th issue. I don't want to rehash, but it answers your question on some level, that there's some level, and again, it also might address part of, maybe better answer some of my harmless error analysis too. What could a jury do? Especially if the jury was correctly instructed, could they have said, we think this is really a firework? That's how he described it, and therefore not a consumer explosive. So I just that's one point I want to make is, even assuming that, there must be some number of things that aren't a scripted explosive device that still would be a firework and therefore not a consumer explosive.
Mr. Hodgkinson, you had an interesting theoretical discussion with my colleague Justice Stiegel toward the end of your original argument about harmlessness, the constitutional harmlessness test being an outcomes-based sort of test. You agree with that it's an outcomes-based sort of test?
I agree with that. That's what this court has held.
And that's why the outcome of nullification should be considered.
I think it must be, if that's a valid and that you might, to the extent that you can evaluate. I understand how hard that is to evaluate. But I'm not...
The possibility must be entertained in order for the standard to be applied appropriately. That's
right.
Your position.
Although I do not think you have to go that far in this case.
Okay.
Because I don't think it's nullification for a jury to look at a particular statute in particular circumstances and say that statute could apply, but we have a reasonable doubt whether it should apply in these circumstances. I wouldn't characterize that as nullification.
I understand.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Appreciate the arguments of both counsel this morning. The court will take this matter under advisement. This time